Thank you, Your Honor. Well, that's just not the case. The plaintiff is, or the defendant mother has had this child basically 24/7 since birth. Yes, they did live together for the first 9 months of this child's life. They split up in December. My client lives in a nice home with his stepmother and his father, and beautiful home on acreage in Galesburg area. She does live in Kalamazoo County, Your Honor, and she plans to remain there. But when they were together this child's only 1 year old, just barely turned 1 year old a few days ago. The plaintiff father really never did anything with this child.
Calling case 2024-244 DC, Nathaniel Charbonneau versus Madison Einart. Today is Tuesday, February 20th, 2024 at 9:02 a.m.
Court will note the appearance of Ms. Kapture on behalf of plaintiff and Mr. Vanderhorst on behalf of the defendant. This matter is before the court on the plaintiff's motion to establish temporary custody, parenting time, and support. Ms. Kapture.
Thank you, Your Honor. I would like to go first through our motion. Plaintiff is requesting 50-50 parenting time. Plaintiff has adequate housing, a crib, all the necessary things for a minor child to be residing with him. Has only been away from the minor child for about a month and a half, maybe 2 months, given that defendant unilaterally moved out of the home and has since prevented him from having near constant contact with the minor child. The minor child is just 1 year old. He is bottle fed with formula, but that's he's weaning off of that currently. He's not breastfed. Some of the matters spoken in defendant's answer are a little concerning. First and foremost, that defendant is requesting that plaintiff attend parenting classes. There is nothing in plaintiff's history that requires him to attend any kind of parenting class. He's had absolutely no interaction with CPS, no domestic violence, no criminal history whatsoever. Both parents are rather young. Defendant and plaintiff had agreed in their relationship that plaintiff would be the primary financial provider, while defendant would be the primary caretaker. This is a very common arrangement with most relationships where one party decides to stop working, take on the primary caretaking role of the child, and the other party is the primary financial provider. That does not mean, however, that plaintiff just absolutely neglected any child care. In fact, he frequently woke up in the middle of the night with the child. He actively fed and bathed and changed the child while the child lived with them. The allegations regarding the shooting in the hand are completely misrepresented to the court. The incident that occurred during a CPL training where the party was at a gun range and there was a misfire of a weapon. This had nothing to do with any kind of gun on the premises. In fact, plaintiff does have his CPL license and is able to have guns. I mean, it's his Second Amendment right. Again, Your Honor, the allegations contained in defendant's answer are largely just made up, created issues that simply are not there. Defendant states that she would seek employment if not for the need for childcare. However, plaintiff has on numerous occasions told defendant to bring the child over to him so that he can provide childcare while she's at work. Plaintiff's family is also willing to provide free childcare, and defendant still refuses to gain gainful employment. Your Honor, there is nothing contained in this answer that would prevent plaintiff from having equal parenting time with his child. It's in the best interest of children to have equal parenting time with both parents. And so, Your Honor, we are continuing to ask for a 50-50 parenting time schedule with child support, obviously, to be calculated pursuant to the Michigan Child Support Formula. Thank you.
Good, thank you. Mr. Vanderhorst?
Thank you, Your Honor. Well, that's just not the case. The plaintiff is, or the defendant mother has had this child basically 24/7 since birth. Yes, they did live together for the first 9 months of this child's life. They split up in December. My client lives in a nice home with his stepmother and his father, and beautiful home on acreage in Galesburg area. She does live in Kalamazoo County, Your Honor, and she plans to remain there. But when they were together this child's only 1 year old, just barely turned 1 year old a few days ago. The plaintiff father really never did anything with this child. He'd work a lot, come home, he'd spend 10, 15 minutes with the child at night. That'd be about it. Then he would play video games. As far as the gun incident is concerned, it's very concerning. He actually shot himself at a CPL, getting a CPL license. He's got a 9mm. Gun went off, went through his hand. Luckily, didn't hit anybody else. It was in a confined area. I know accidents do happen. I'm a gun owner myself, but the pictures that I saw of AR-15 against the wall in the home that my client lived in with him, shotguns, rifles out in the open, is not tolerable, cannot be tolerated. Any type of parenting time he has, all weapons should be locked safely, secured in a safe. He also carries quite frequently. We don't want him carrying a weapon when he's got the child. So we absolutely, that's a mandated thing, Your Honor. But as far as the child, I mean, he's just hasn't happened, hasn't bathed the child, didn't feed the child, didn't diaper the child, didn't ever go to the doctor with the child. All those things fell on my client. So going forward, we would ask that, I mean, he has some parenting time, and my client's never denied him parenting time, Your Honor. Either there's a sickness, I think there's a germ phobia over there. If the child's sick or sniffling nose, doesn't want to have the child. I mean, we offered this week for him to have the child a couple of times, and he was sick, so he couldn't do that either. So there's always some excuse there. But going forward, I would say that well, actually, his parenting time classes would be good. My client feels he doesn't really know how to care for an infant. I think there's opportunities in Battle Creek area with community fatherhood, various places where he could get some skills for parenting time when he has his parenting time. So going forward, we would say, custody remains with my client. Legal should remain with her as well. The child is on Medicaid. My client is not working because of the fact of the expensive daycare, which could be $200 a week. I mean, she is looking for work and she will ultimately go back to work, but at the present time with an infant, she's been home with him. So going forward, we would say that there is the policy that Calhoun County goes with. But my client would really like to have, has opened up her home, that if he wanted to visit there for 3-4 hours, and then we could ramp up to something more, Your Honor, to, ultimately an overnight maybe with him, as long as all the safeguards are in place. No guns. He has some parenting time classes. And then we go forward, Your Honor. Okay. And then, I think a child support order ought to enter per the guidelines.
Okay. Mr. Vanderhorst, you pushed for parenting time classes. Is your client willing to take parenting time classes?
Yes.
Okay.
Yes, Your Honor.
Okay. Ms. Capture, response.
Your Honor, again, the incident with the gun has absolutely nothing to do with the minor child. All guns in the home are adequately secured. And my client has said that if that is a barrier, he's willing to remove the guns from the premises altogether, simply because he wants to have time with his child, which is the right of every single parent in this country. There is nothing in his history that would prevent him from having adequate time with his child. Half and half. That is exactly what he is entitled to. He has no criminal history. He has no mental history. He has absolutely no domestic violence. There is nothing suggesting that he shouldn't have 50-50 parenting time. At minimum, he should be awarded afforded standard parenting time. He has adequate housing. The child can stay in the crib in his home. There is nothing suggesting that he would be required to take parenting classes. Certainly, he would be open to the idea, but for them to be court ordered is as if he is being punished for being a young parent, which so is defendant. Many parents in this country parent without parenting classes. There's no issues with sobriety. There is no issues with drugs. Nothing within the requests that defendant is stating is warranted in this matter. These are both able-bodied parents who have divided their parenting responsibilities, where plaintiff was the primary financial bringer and defendant was the primary caretaker. Now that defendant has decided to leave the house, she believes that she is fully entitled to the child and plaintiff is not. That's simply not how this works. Plaintiff should be able to have his 50% parenting time and take care of the child just as much as defendant should, and defendant should be required to have a job. That is what we are asking for, Your Honor. Again, we are fine with paying child support. My client is fine with removing the guns from the premises. But at minimum, there should be standard parenting time. But in all fairness, it should be 50-50.
Okay.
Thank you.
Anything else, Mr. Vanderhorst?
Well, Your Honor, I believe 50-50 is, I mean, not even close to what's in the best interest of this child. Defendant Mothers has really the established custodial environment since birth, even though they might have lived together 9 months. She's raised this child. Father's been absent at work, and even when he's home, he's absent. So I would say the ramped up, the parenting classes are fine for both parties if that's what the court wants to do. But I think we do some sort of ramped up where he has a few 3-4 hours a week or a couple times a week, whatever the court says, and then ultimately get into some overnights on the weekends when, quite frankly, plaintiff's ready.
Okay. Well, the court has read the pleadings in this matter as well as heard the oral argument in this case. Obviously, there is nothing in the record or as stated that would require parenting time classes by either parent in this particular matter. When the hospital sends a child home from the hospital after birth, they don't require that the parents take parenting time classes, nor do they give them, you know, an outline or anything else. And I don't see anything that's been submitted or alleged in this matter which would require that. So the court just looks at that as just a red herring in this particular matter. Likewise, the issue of the gun, there was apparently an accident during the CPL class. The court doesn't infer anything from an accident happening. Obviously, you're taking the classes, and maybe something obviously didn't go right at that because you don't hear of it, but it doesn't infer that somebody had done anything wrong or mishandled, that simply it was an accident. So the court will not take any action or restrictions as it relates to the gun in this matter as well. It does appear, based upon what's stated, is that the parties were together with the child till sometime in December, that they separated at that particular time. Up until that time, they both had equal access to the child, had equal involvement, although one parent, in this case, the plaintiff, the defendant may have done more. Court looks at the Bothasill case and states in that one that said that each party contributes differently to the raising of the child, but you cannot minimize one of the parents' involvement because they don't do anything or the same things as does the other parent. What the court's going to do, based upon the young age of the child and based upon the fact that the parties were involved equally prior to the separation, a court is going to grant to the parties joint legal and joint physical custody. The court will set parenting time on a 2-2-3 schedule, and I assume that the child is with the defendant at this point, so she will, commencing today, will get her 2 days, and then thereafter the the plaintiff will get his, and then the 3 days thereafter. So put the start dates in that miscapture. The court will, in this matter, impute income to the defendant there a labor shortage in all the communities and in the state, and anyone could get a job at $15 per hour. The court will impute $15 per hour to the defendant and utilize the sum of $17 per hour, which was the stated income of the plaintiff in this matter. Ms. Capture, you can calculate that support as well. That will be the order of the court on an interim basis. Anything else, Ms. Capture?
I have nothing further. Thank you, Your Honor.
Mr. Vanderhorst?
No, Your Honor.
Okay, Ms. Capture, you can prepare that order and submit under 7-day notice.